Welcome back. I'm here with Kyla Thompson from Varnum Law, and today we're going to be talking about the law.
That's right.
Legal law. All right, so first we're going to start talking about agendas, notices, posting them. There's been a lot of law changes about that. And actually, which I should have given you the heads up and didn't, we probably should talk about some of the new law changes that went into effect last year. And if you want to, we can touch on the ones that are coming into effect. Or if you would prefer, I'll give you a pass and we can have you come back and we can talk about those after they go into effect in July.
Likely after they go into effect.
All right. So let's start with agendas. There's some change in those legislation, particularly when it comes to condos. Now, when we post an agenda for a condo, if we're voting on a contract, the contract needs to be posted with the agenda or referenced as being available on the website, that kind of thing. And it needs to meet the same posting notice requirements as the notice itself. So for 48 hours, we have to post it on site with the notice, and we have to post the contract at the same time, correct?
Yes.
Can we also post it? So if we have it on the website, do we have to reference that it's on the website on the agenda?
If you're posting the contract, if you're posting the agenda on the website, then you're going to have to post it on the website also for the contract.
So what I'm thinking is like, let's say that we post the agenda on site and we say that the contract is available on the website. Do we need to say the contract is available on the website, or does it just need to be available on the website?
That's a good question. Generally, I would say that if you're going to post your agenda on the website, you're also going to post the contract that's going to be subject to discussion on the website itself. It becomes one package.
Right. But so what I'm thinking is some of our associations also post the agenda in person.
Yes.
So if it's in both places, I just don't know if we have to reference it or not.
I'm not sure about the referencing. I think what I would prefer to do and what I would recommend the associations do is that if you're going to post the agenda physically, you're going to have to put a copy physically as well of the contract physically. And then if you put it on the website, the agenda and the notice on the website, you need to have that document on the website also.
So if we're posting our agendas physically, we need to post physical contracts.
Yes.
That's the plan. We can't just post it physically and have the contracts on the website. Got it. All right. We were talking about HOA notification requirements, which are a little bit different. Starting with the notice of the board meeting. If we need to post it on site, it's a 48-hour posted notice for a board meeting, just like
correct.
A condominium would be. But in many of our associations, we have no place we can post it on site because we have HOAs that have no common property anywhere. So we usually take to either email or mailing it out.
Yes.
And that's a 7-day notice, correct?
That is a 7-day notice. You are required to mail it out under the statute. However, if most or all of your owners have consented to electronic notice, which is essentially something like save the stamp, instead of sending it out by mail, send it to me by email instead. So if your owners have consented to that, you can email it to them 7 days ahead of time.
All righty. So that is our solution on our HOAs that don't have notice boards, that kind of thing. All right. Now for the third rail that we've had for a few years now, emotional support animal. This happens quite often. We've got a person calls up and says that there is a dog in a unit.
Yeah.
But they're not on the application or anything. So what should be the first thing that we do when we have a report of any animal in a unit, whether it's an ostrich or a dog?
Call the person who owns the dog or said ostrich.
Okay. So we're going to call the person that owns the dog or ostrich.
We need to confirm that there's actually an animal in there. If we assume that, let's say it's a no pet building or this animal is much larger than what is allowed in a certain condominium association, then we need to confirm that there's actually an animal in there and determine whether or not the person that owns this animal is requesting that a reasonable accommodation.
So let's pretend, and we should do that by phone or by mail or email and the reason I ask that is I've recently come to this conclusion. I've had this epiphany after a situation which we were both involved in, which it was, I don't know if you know which one I'm referring to, but it was a situation that went very badly for that association. And I don't think the association did anything wrong. It was an agreement between one association and another association. And I've now come to the conclusion that it's not really what happened. It's what you can prove happened. So in this case, should we be, because the phone call is the easiest method, right? It's the friendliest, it's the quickest response. But if we make that phone call, we can't necessarily prove we made that phone call.
Right. You can't prove it was discussed at the phone call. In these situations, especially if we have a very credible request for a reasonable accommodation, it is looked on as perhaps overly aggressive if we start emailing right away. What I would first recommend is you make a phone call. And you make a phone call just to determine what's actually occurring. But that doesn't mean you can't confirm in writing. So what I like to recommend is you make the phone call, you make that initial contact, and then after you send an email to confirm the discussion and to say, we expect or we would like to receive the documentation regarding the emotional support animal within a certain number of days, whatever it is that the board has recommended or has requested from the manager.
Got it. So we're going to make the phone call. They may or may not say that it's an emotional support animal. If they do say that it's an emotional support animal at that point, we're going to be moving forward and trying to gather that information. So what information do we need to support the emotional support animal?
Well, it's certainly not a certificate that you can buy online.
Got it.
So if somebody gives you a certificate that says Rocky, my pit bull, is an emotional support animal, that's not enough. You are required as an association to request a certificate, or a letter from a medical professional or a mental health professional or someone who has the credentials to say that the person has some sort of a disability, and the fact that there's a disability is now impeding their ability to enjoy the common elements and their units the same way as someone without a disability. And because of that, they are prescribing the emotional support animal, because the emotional support animal is not a pet. It is a tool that this person needs to be able to fully enjoy the unit and the common areas just like everybody else.
Okay, so a doctor's note, in short.
A doctor's note, a social worker can work as well, psychologist, therapist. Those folks are usually the ones that are drafting these letters.
Now, what is the difference between an emotional support animal and a service animal?
Great question. So an emotional support animal has no type of training whatsoever. We like to use these terms like they're the same, but they're not the same. A service animal is trained for a job. They usually go through months and months of training, and it's usually connected to a disease or some sort of disability that if something is triggered, like epilepsy, or if a person is blind, that the animal actually has a job to do. The emotional support animal doesn't necessarily have a particular job. It's just that it provides support, emotional support to the person with a disability.
Got it. Now, what is required for the service animal?
It's a lot less than the emotional support animal. If somebody says that they have a service animal, you may only request information such as, do you have a disability that needs a service animal? If the person answers in the affirmative, you can then ask, does this animal provide a service to you? And if the answer is yes, we're done.
Got it. So we can't ask what the service is or anything like that.
No, and usually you can very much tell that service animal because they're very well trained. They're not running around in any of the common areas. They're usually right by their handler or their owner. Sometimes the disability is apparent. If the person is blind, you can tell the person is blind. Epilepsy, you can tell.
I have a question about the epilepsy and how you can tell, because so we had a situation here at one of our associations. There was and obviously we do not condone any of this. We had a situation where there was a person came with a service animal, and the board member wanted to know that it was a service animal. Yes, it is. Why do you have this service animal? And he said, it's for epilepsy. The president asked the person to lay down on the ground and shake to see if the dog would do anything. And at that point, actually the manager who was there said that this interview is over and just stopped the whole process and said, we need to stop this. Obviously the person did not lay down or anything. And I think there was a moment where we thought it was almost like a bad joke and he was being serious. How would you know that it's for epilepsy?
You really won't know that.
So you just have to take them at their word.
Yes, unless and until something occurs and people are able to see it.
And what documentation can you request for a service animal? So pretty much I come in, I say, this is my service animal. You have to take me at my word. And if that happens at the association and they say, this is a service animal, not an emotional support, that's the end of the discussion.
That's the end of the discussion. Unless and until you have information that would negate or call into question the fact that the animal is a service animal. Again, service animals have gone through all sorts of training. And so you will very rarely see a service animal going after another animal or a service animal that's wandering around and not directly by their handler or their own.
All right. So if a board says, I don't believe this is a service animal, what do we do?
Well, I don't recommend it. However, you can question the person some more, and you could try and ask for documentation to determine whether or not this animal is actually a service animal. Sometimes the owner or the handler will provide that documentation. When you get that recommendation, I usually would say, okay, that's enough. Let's put this in our files and let's walk away, approve the fact that the service animal is in the building. If that's still not enough for the board, then we can pursue to have the animal removed. Usually that's when we start receiving the petition or the complaint from the Department of Housing and Urban Development or the Florida Commission on Human Relations. And that's when we stop having to interact with the owner and now have to interact with our governmental agencies to determine why we're pursuing someone who needs this animal with them.
Is there anything that the association can do for the period of time before the animal was disclosed? So if you have a requirement that you're not allowed to have a dog,
yes,
and someone had a dog during that period of time, that in itself is the violation, right?
Right. But remember, it's not the fact that you can or can't have the dog, because what we're trying to prevent by having no pet buildings or no pets under or over a certain weight is the pet. This animal is not a pet, it's a tool. And so I don't think there's much that you can do, especially, if it's a credible request for a reasonable accommodation for either a service animal or an emotional support animal, there's not really much you can do, specifically if the request is needed and is credible.
Shift gears a bit and let's go to fines, violations, notices, in particular trash cans and parking, because a lot of the new legislation has impacted trash cans and parking.
Yes.
The struggle that we're having as managers now, not only is the fine and violation procedure different, and I'd like for you to walk through what you think is the dream violation procedure. Like if you have the perfect process for issuing a violation, I'd love to hear it. So let's start with that. What's the perfect violation process?
Well,
let's go with dirty roof, because
that's easiest. Or even a house that's painted a particular color that's not within the violation or the paint color palette. First things first, you send a friendly violation notice to say, owner, you might not have known, but your roof is dirty. Could you please clean your roof within a certain amount of time, let's say 30 days. And so you provide that very nice, friendly notice and nothing happens. And so the next step is then the board determines, what do we do here? The HOA statute was changed last year to be very specific when it comes to the formal finding notice. So the friendly notice does not have to contain all of the elements that the statute now requires, but I like to say add it all in there and be as transparent as possible. So not only do you say in your first violation notice, your friendly notice, owner, it looks like you have a dirty roof. Section 3.5 of the declaration says you can't have a dirty roof, or section 2.2 of your rules and regulations. So you reference back to that document. How do you fix it? Please clean your roof within the next 30 days. That needs to be contained in every single violation letter now. You have to be very specific as to how you can remedy the violation. Let's say it's not fixed within 30 days. So some boards will send another notice. If you haven't received response from the owner saying, I'm so sorry, I didn't get to it in the 30 days, give me another 15 days, I'd say, you can send another friendly, not quite as friendly violation letter, or the next step would then be, let's have a board meeting and let's propose a fine. And the statutory fine amount is $100 per day, up to $1,000 for a continuing violation. And so you know that already 30 days has passed with that dirty roof. And so you already have your $1,000 because it's been more than 10 days. And so at this board meeting, you would have the board meeting notice, 48 hours, posted ahead of time, be specific that you're going to fine, be specific regarding the address. So you don't just want to say fines and have nothing in reference to a specific address. You want to write it in the agenda that you're going to have an address. And then at the meeting, the board will talk about the fine, make a motion to approve a certain amount, second, and the board votes to approve the fine. Okay? At that point,
we're halfway done.
That's right, we're halfway done. You have to set up a fining hearing. And the fining hearing now must occur within 90 days after you send your notice. Now, this notice, the notice of the fine hearing. So this notice, you have to tell the owner that they're going to have a fine hearing. It's their opportunity to get in front of the fine committee to say, no, don't fine me. I'm going to do this, I'm going to do that, or the fine is unjustified. Whatever it is, it's their opportunity to speak to a neutral third party, a neutral committee or group of people. And so the notice of that fine hearing must be 14 days after you send the notice. So at least 14 days. It gives enough time for the owner to be noticed that there's a fine hearing coming up. And then that fine hearing must occur within 90 days of that 14-day notice being sent out, which is very reasonable. It should happen sooner rather than later. Okay, so we've sent out our notice. You have your fine committee, which is 3 people, at least 3 members of the association who are not related to the board, live with the board, employees of the association, anything like that. The goal is that you have neutral folk.
Do they have to live in the community?
Yes, they have to be members of the association.
Well,
they don't have to be residents, right? They don't have to live there.
But they have to own a unit.
Yes, they have to own, because then they have some buy-in to the community. And so you get there to the fine hearing. Before that, the notice again has to contain what is the violation, how do you remedy the violation, what is the provision in the governing documents or the rules and regulations that's being violated, and now what is the proposed amount of the fine. Okay, so you send that out to the owner, and then you've got your fine hearing. You show up at the fine hearing. The biggest thing for these fine hearings is that you must allow the unit owners to speak. You have to allow them to speak. There is no 3-minute rule where you can say, okay, well, you're all done, let's make a decision. You have to let them speak, because guess what? It's their opportunity to sway someone, all right? And so let's say the committee is not swayed and they approve the fine. Now we have to send out another notice to the owner. And the notice now says, hey, we approve the fine. You must pay this fine. And now the statute says they have 30 days to pay the fine. And what's the kicker here is that the statute says if the violation is remedied, let's go back, after the first notice, which makes sense, after the fine hearing notice, but before the fine hearing, which makes sense, after the fine hearing, which kind of doesn't make much sense to me, but that's what the statute says. But if your violation is remedied at any of these 3 points, you cannot pursue the fine.
So I can go through
months and months of work. And, I just said the fine is due within 30 days of the notice. You get to day 29 and I clean my roof and you cannot pursue the fine.
Got it. So
that's my dream scenario, but that still allows for a unit owner to fix the issue right in the nick of
something like hurricane shutters. Let's say we're going to go with 2 different parts of this. First is, let's say someone has their hurricane shutters up inside of hurricane season.
Okay.
Is there any prohibition that would stop an association from going after them if they have in their documents that you can't have hurricane shutters?
But it's within
hurricane season. So hurricane's not coming, but like right now, let's say that I have my hurricane shutters up. I live in Apple Tree Association. Can an association fine me for having my shutters up?
If it's not within the timeline, if you've got a provision that says your hurricane shutters may only be up 5 days before a named storm, must be removed within however many days after the hurricane has passed. Yes, you can pursue that.
So now, next side of this, my understanding is that there is now legislation in place that unless we have something in our documents defining what can be installed with hurricane shutters and with regards to hurricane protection, we pretty much have to let them install whatever
they want. Yes.
So now let's move to, there's nothing in the documents, and I go ahead and I install, without ARC approval, hurricane shutters.
That's right.
Did I violate it?
Not according to the statute. If you don't have any architectural standards that say you want to install hurricane shutters, and there's nothing in the architectural standards or the declaration that says you must have white colored hurricane shutters, and you decide you want just the regular metal hurricane shutters, the statute will now protect you. Because what the statute says is if the association wants the right to say anything about these hurricane standards, they have to have something written down for the owners to be able to know that if they want hurricane shutters, it has to be this specific type. So it's about transparency. It's about making sure that owners are aware of things so that they don't have to guess as to what the association is thinking.
So I guess the question now is with the hurricane shutter installation. So if there is nothing in our guidelines that says anything about you have to have specific shutters, do you even have to go through an ARC approval to install?
Great question. It depends. It depends on every situation.
I should also tell you, you're actually kind of famous. You don't know this yet. You're famous in a number of other discussions we've had, because anytime someone says it depends, I'm like, oh, God, it's Kyla.
It's true. There's a meme that I saw the other day that it says somebody was holding a magic 8-ball and it said, it depends. And somebody else said, oh, you must have the lawyer edition of the magic 8-ball.
Yes. So, and this is an area that we're kind of trying to figure out right now. So we've had associations in the past that they don't have any requirement for hurricane shutters, but they expect people to submit an ARC request for pretty much any exterior modification.
And that's what it says in most governing documents.
And so the argument is that the exterior modification is hurricane shutters. But now I'm giving you a real-time example of something. So I guess I always thought they were still going to have to submit an ARC request, but the owner's position is you couldn't deny it.
I think it's not about being able to deny or approve it at that point. It's about having documentation, because we want to make sure that we know what the changes are based on a certain lot.
So we can still require them to submit an ARC application, even if we're not going to make
at that point it's about documentation. So instead of having, for a regular application, you would request perhaps the license or insurance of a specific vendor and all this stuff, and then review it based on the entire package. But we wouldn't have any review at that point. The shutters are up, and so at that point it's about documentation, making sure that we have records for each lot.
All right. Now, whether it's a fine or whether it's their maintenance fee that's come in, how do we handle collection?
How do we handle collections?
I know how we handle collections. How do you handle collections?
Okay, so the statute was changed a few years ago, about 4 or 5 years ago now, to require a notice of late assessment, NOLA. And it says every association before this time was pretty inconsistent regarding their late letters. And so instead of waiting and determining which association has which late period, the statute established a late letter for owners. And before you can send it out to an attorney and incur attorney's fees, you must send out this letter called the Notice of Late Assessment that basically says, dear owner, you haven't paid, you might have forgotten, whatever it is, here are the amounts that are owed. Please send it to us and pay us within 30 days of this letter. And if you don't, then we can begin legal action against you, legal collection action against you. If the association doesn't send this letter prior to incurring attorney's fees, regardless of if the owner ends up paying later, the association won't be able to collect their attorney's fees. And as we both know, those can rack up pretty quickly. So we want to make sure to protect our right to obtain those back. So that's the first step, and that's 30 days. So the second step will be the notice of intent to lien. So language is pretty common and pretty similar to the notice of late assessment that basically says, hey owner, you didn't send us payment in response to your notice of late assessment. And so please note that if you do not send us payment within 45 days of this letter, here are all the amounts that are owed, then we will be allowed to put a lien on your unit or your home.
The reason I'm bringing this up is I think this is a misconception with a lot of our directors. They hear the 45-day letter and think it's 45 days after what's coming due. So for instance, we're doing this in June right now.
Yeah.
The next fee that's coming due is going to be July 1st. Now, for most of our associations, it's actually not even late till July 10th because there's a grace period. But the 30-day letter is very likely not going to go out till the first week of August. There's a, Sean Friend was here. We were talking about lockboxes before. There is a slight delay in lockbox processing. And so we do want to, it's as quick as it can be, but we do want to give them a couple of days. So we're going to end up pulling that information in August, 30 days out from what was due then. Now, 45 days further out from that, we're talking, so we go through all of August and we're through half of September.
Yes.
Right?
Yes.
And at this point, we're sending this pre-lien letter. So we're into the middle of September.
And now we're sending out the notice of intent to lien, and that's 45.
And by the way, when is the next set of dues due?
October.
There you go.
So now we're in mid-October by the time the notice of intent to lien is finished. Mid-October, even early November. And so now we've got how many?
We've got 2 quarters that haven't been paid.
2 quarters.
And the second quarter is closing in on 60 days past.
Yep, exactly. And then at that point, now we record a lien against the property. Because like we said in the pre-lien letter, the notice of intent to lien, if you don't pay, then we're going to record a lien. So now we record a lien.
Which we're
And-
now probably into late November, early December.
Yeah. And now we send a letter that says, it's called the Notice of Intent to Foreclose. It says, owner, as we told you in the Notice of Intent to Lien, please pay us or we're going to lien your property. You didn't pay us. So now we've liened your property. Now this is our notice to you that we have the right to foreclose on your property if you don't pay us within another 45-day period. So now we're what? End of November, early December. We've got January dues that come due prior to our 45-day period ending. So now we're into it for 3/4 of unpaid dues.
And you're going to be halfway through January and getting into February.
Yes, before we can
Before
have
you
a
can even
conversation
start the real
about
foreclosure.
a foreclosure. What is the best way to handle this?
If even foreclosure is the best way to handle it. There are times, I would say more times than not, we find it's best not to foreclose. Usually, I mean, I think we're very intelligent people. Well, I think you're a very intelligent person. I wouldn't say I am. But my experience has been if something's worth foreclosing on and someone's not paying, the bank is faster than we are.
Yes, or there is a mortgage foreclosure already ongoing,
Correct.
and we can encourage the bank to foreclose faster. And so I've had some associations which have come to us, who have come to our firm, and they have a policy that essentially says, anytime there's a lien on the property after 45 days, doesn't matter, no need for discussion, foreclose. That's the wrong way to go because every situation is different. It's a case-by-case analysis. If there's no mortgage on the property, absolutely. I agree. Let's foreclose. If the owner wants to keep the property, we will pressure the owner to end up paying. But if there's a mortgage on the property, we need to determine, is the owner just not paying the association or are they also not paying the mortgage? Because the first mortgage is always superior. And so there is no point in fighting. If you're in a sub-association and there's a master association, if you're not getting paid, chances are the master's not getting paid. And now are we going to have competing mortgage or lien foreclosures? That's not ideal. So different situations, if there's a tenant in the property, did we have to go all the way through or could we have collected the rents to pay off our account? So different situations will always show up. And I don't believe in a one-size-fits-all policy when it comes to collection.
Yeah, I agree. I guess what we end up seeing, the most common fallacies, the most common errors that we see is boards we have a very standardized, so at Newell, we have a very standardized process. It's basically automatic. We're going to do it.
Yeah.
And so what ends up happening is some associations, the boards will want to review, do we send out these notices or do we not on a per individual basis? That's become a problem in two ways for us. The first is that we're not applying this evenly, and that can be an issue down the road that we don't really want to deal with. The second is, on top of us not applying this evenly, if you just wait, I know that Fred, he's a good guy, he'll pay it, give him a phone call, do this, do that. Well, we've already extended it. We've just established that it can take you a year, basically, to get yourself up to speed. Mm-hmm. So if you delay that 2 or 3 months, that gets out further and further and further. And then owners are wondering, why are we not doing collections? Well,
Right.
we are. We're doing it as quickly as possible. The other problem that I've seen is the phone calls instead of the letters. Making phone calls. We have seen problems happen with Fair Debt Collections Act, where we're calling phones that we were not allowed to call during business hours. And that's gotten us into trouble.
It goes back to phone calls. How can you prove that you actually called this person? What did you have? What did you talk about?
Yeah,
So-
it doesn't. They wanted, it's supposed to be a friendly reminder that email and mail works well. And really, if we follow the statutory process, it works quite well.
It does.
The other thing that happens is, generally speaking, associations will run 1%, 2%, 3% delinquencies. I think that I was looking at an average, and I can't remember if it was CAI who released it, and it's actually 2 to 7% is what the association should average, right? So if you've got a 200 unit HOA, and you've got 6 people that are delinquent, you're within that average. So that's normal, and the process is designed to handle that. And then the last thing I see is we get upset towards the end because it's taken so long and we just go ahead and foreclose. And very often, banks are very good at foreclosing when it's advantageous to them to foreclose. If the bank isn't foreclosing and we think we're geniuses and we're foreclosing, there's 2 problems. The first is we're not really foreclosing. I mean, we're foreclosing, but we're still subject to the mortgage that exists. And the bank probably has done their analysis and they're like, listen, this is
not the time.
not the time. Don't do this.
Yeah.
Better yet, oftentimes when somebody has walked away from a situation where they call it being upside down in the mortgage, the unit is going to be substandard.
Yes.
So the best case scenario we have is we're going to become landlords, right? We're going to foreclose on this for a period of time and we're going to rent it out. Except they could have stripped out everything inside the unit. There could be mold. We could end up putting $20,000 trying to make this work. And now we want to try to get a tenant. And I realize I'm kind of getting off point in this.
No, this is a good situation. So I've seen this happen several years ago where we've spent months and months and months foreclosing on this property. And we received the property and we spent a couple months now getting it ready for tenancy and getting it ready for rental. And then within a month, the mortgage foreclosure was filed. And
that's the reason we're not smarter than the banks.
Yeah, and you're hoping to not only recoup what you spent in the mortgage foreclosure, what you spent to get the property back up and running to be rented, and also everything else in assessments that haven't gotten paid. But now, because the mortgage foreclosure was filed, you don't have an infinite timeline to get that rent back or to get all the amounts back in rent. You have a very limited timeline now, and you know you're not going to get the amounts that you're looking for to pay yourself back.
Yeah, sometimes, I think that the statute works well. And most of the times, associations will always recoup everything.
Yes.
Generally, like 95% of the time.
Yes.
But there is a 5% of the time where we need to, and it happens more often in condos than HOAs. I see it happen more often in condominium associations where there might be a loss. And we need to decide which is the lesser loss to take.
Right.
And us foreclosing and rebuilding a unit will just make that loss worse.
Yes, I've only seen it really succeed in the last 14 years, maybe 3 or 4 times. And those were very special situations where the bank had essentially walked away as well. And that doesn't happen very often.
Yeah, and even right now, just renting, I've been having a number of conversations with folks that are in real estate. It's hard to be a landlord and make money. As strange as this sounds, because we've all gotten used to this, landlords, they make lots of money. Well, when you look at the association and what it's paying, associations operate net zero, right? Most of your dues, if you're a condo, most of your dues are going into your insurance and all of that, which is way up. If you foreclosed on a single family home, you still have to pay the insurance. So you've got all of those costs coming out. And then on top of it, you're paying, taxes, all of it. And you're trying to recoup this off of the $2,000 a month that is going to be coming in, but you don't know how long it's going to come in for in this case.
And you might not be able to rent it out at as high as you would have liked, because whoever comes into the property as the tenant is also accepting the fact that they might get kicked out because of a mortgage foreclosure. And so if the house is worth $2,500 a month, you might only be able to charge $1,500 a month in rent because of the risk that the tenant is.
For worse yet, you end up with the tenant who's not paying. And now we're subject to the same
now we've
trying to get them to leave with an eviction. And now we're incurring legal costs to evict a person. All right, we're going to take a little break and then we will come back with our second half.